Hello UPSC aspirants, how are you? As a part of our video clarification sessions, I have received a beautiful query from one of our wonderful aspirants. ICCPR, ICESCR, Bill of Rights. What is the relation between them? I would like to ask you a question before starting this session. Why do we need rights for? All human beings are born free and equal in dignity. In order to protect ourselves from the excesses of the state or the fellow human beings, we have designated some rights either in constitutional provisions or in our laws. In 1946, United Nations has constituted a commission to draft International Bill of Human Rights. What is the backdrop of 1946 that has given this thought of forming a or drafting the International Bill of Human Rights? Backdrop of 1946. Whenever we start a concept, it is advisable to see the backdrop for the comprehensive analysis of the whole concept. If we analyze the backdrop of 1946, we have seen two world wars prior to 1946. We have seen many barbarous acts during this period against the rights of the individuals and the dignity of the individual. War crimes, and we have seen slave trade. We have seen illegal human trafficking. We have seen the worst forms of racism, fascism. We have seen objectification of women. All these have created conditions for thought provocation by UN to constitute a committee or commission to draft International Bill of Rights. As a result, on December 10th, 1948, Universal Declaration of Human Rights have come into force. It consists of 35 articles. Civil rights, political rights, social rights, economic rights, spiritual rights, etc. All the spheres of the human life has got some rights. All are declared in UDHR, Universal Declaration of Human Rights. And all the nations are signatories to this. Since it is a declaration of human rights, it has got no legal backing. It is not enforceable. That means there is no mechanism defined in declaration for the aggrieved party to seek remedy from UDHR. If it is not enforceable, why do we need Universal Declaration of Human Rights? That is the significance. It acts as a moral force for the countries to adopt or to enforce human rights in their countries in the name of laws or constitutional provisions. One more significance of UDHR is it helped to form various conventions and covenants in international arena. That is International Convention on Elimination of Racial Discrimination, International Covenant on Economic, Social and Cultural Rights, International Covenant on Civil and Political Rights, International Convention on Rights of Children, Convention on Elimination of All Forms of Discrimination against Women. ICESCR and ICCPR along with UDHR are called as International Bill of Rights. UDHR is not enforceable, but ICESR and ICCPR are enforceable in nature. That is, they are legally binding. What is the difference between convention and covenant? Convention is a meeting of the parties to discuss the matter of significance or importance. Covenant is legal agreement. It's a legal agreement among the parties on the rules of the matter of significance. UDHR is just a declaration. It just mentions all the human rights in its document. It is not enforceable. Declaration is not enforceable. Covenant is enforceable. Conventions can be made enforceable. Since Universal Declaration of Human Rights is not enforceable, it has led to the formation of ICCPR, ICESCR. All these two covenants are enforceable in nature. International Covenant on Civil and Political Rights. It came into force on March 23, 1976 with 173 signatory countries right now. It has got 51 articles divided into 6 parts. Examples could be freedom of speech, freedom of expression, right to form associations. ICESCR, International Covenant on Economic, Social and Cultural Rights. It came into force on March 3rd, 1976 with 173 signatory countries. Right now, it has got 31 articles divided into 5 parts. Examples could be right to education, right to employment, right to have equal pay. If we take UDHR as this scope, then ICCPR, ICESCR. ICCPR have got civil and political rights. ICSCR has got economic, social and cultural rights. Their scope is very less compared to UDHR. UDHR has the scope of all the aspects of human being. The main purpose of the formation of these two covenants is to promote the conditions for the enjoyment of these respective rights in the states. How they can they promote? Human Rights Committee in the respective covenants are formed. It will report the conditions of the human rights in the country. With this report, it can make the states responsible to the citizens of its country for the human rights, for the enjoyment of the human rights. Next is enforcing the human rights, respective human rights in the states. How this enforcement happens is through optional protocol. Under this optional protocol, the aggrieved party whose rights are violated by the state can approach the HR committee. For this, there is one condition. The state has to be signatory of any of these covenants. If a state is signatory of this covenant, only the aggrieved party can reach if the rights under this covenant are violated. If a state is signatory of this, the aggrieved party can approach this covenant HR committee only if the rights under this list are violated by the state. If we talk about examples, we have seen eviction of Palestinian homes by the Israelis. We have already seen the use of minority language is banned in Sri Lanka. We have already seen the ethical cleansing by Myanmar. All these excesses have been done by the state. What should the people do in this kind of scenario? They can approach to any of these covenants and complain. Through this optional protocol, the aggrieved people can get remedy. The HR committee goes to the state and does investigation and gives the report as well as the remedy to the people. If we see the Indian constitutions, the fundamental rights and directive principles are in line with UDHR and ICCPR and ICESCR. So we can say the Indian constitution makers are far-sighted and they are in line with international forums. If we want to talk about similarities of UDHR, ICCPR and ICSR is they contains the human rights that had to be made enjoyable by all the human beings. If we talk about dissimilarities, UDHR has vast scope of rights and it is not enforceable in nature. When we talk about these two, they are enforceable in nature and the rights are in particular spheres of the human beings. I hope you understood the concepts in this session. If you have any queries, you can write us in the comment section of our videos or WhatsApp message or text message to the number given in the description box. If you like our video, please like, share and subscribe to our channel.